is Jerry Glas. He's a partner at Deutsch Kerrigan and Stiles in New Orleans. Jerry has taken over 70 jury trials to verdict. He is also trial counsel for Taser and is highly regarded among the Taser defense counsel because he voluntarily decided he would take a 5-second Taser probe to the back in an effort to really experience what it felt like. He denies that he cried like a baby. Here to give us a jolt with ethical considerations when parties and jurors use Facebook, Twitter, and blogs. Welcome, Jerry Glas.
All right. In Greek mythology, Pandora's box was said to contain all the evil of the world. But today, as the father of 2 daughters, I can tell you with absolute certainty that the true repository for evil is, of course, the internet. From videos of stunning teenage stupidity to wildly inappropriate blogs and posts, as a parent, it is the bane of my existence. As a lawyer, I think it's fabulous. I can't imagine practicing law without it. It's like God decided he was personally tired of listening to people lie during voir dire and depositions. People like one widow who sued the police because her husband died shortly after they responded to her 911 call. Now about this man, thank you. Now about this man who had enough cocaine in him to kill a small elephant, she told me during her deposition that he was wonderful to her, that he was the love of her life. So I handed her her MySpace page, and I asked her to read for me the sentence after she had written, "My husband, the a-hole, died in February." She looked at me. If looks could kill, I would not be here today. And she read, "Don't apologize. I am and have been in love with the first love of my life from age 15, Michael." Same MySpace account. I learned that Michael is what she had wanted for a very long time, and I also learned that she was, in fact, in love with Michael. Date of the post? A month and 10 days after her husband died. Yes, the internet is a gift, an irresistible gift. We all have success stories just like this, which make us somewhat more interesting at cocktail parties. But each one of these successes begs the question, do we have an actual duty to investigate? Well, during that deposition, I asked her, when were you and Michael intimate for the first time? And she told me she would not, her attorney instructed her not to answer, and she refused. But she had already posted video of her waking Michael up in the morning. Now, I'm not going to play the video out of respect for Michael, okay? But their witty banter made it clear that they had been intimate earlier that morning. So, yeah, the question is, do we have this duty to investigate online? Rule 1.1, of course, tells us that we have to be thorough and we have to do reasonable preparation. Comment 6 says we have to keep abreast of changes in the law and its practice. And comment 5 says that we have to use methods and procedures meeting the standards of competent practitioners. Well, that's a good question. How do many practitioners prepare to depose or examine parties and witnesses? Well, we know where they go. They go to YouTube. YouTube has over 800 million unique users each month. Each month. In the last 30 days, more video has been uploaded to YouTube than the 3 major networks generated in 60 years. By the way, the most often watched non-music video, Charlie Bit My Finger, with 136 million views. Ouch, Charlie, that hurt. You go to Twitter, where you've got 100 million active users now. In the United States alone, by the end of this year, you'll have more than 21 million users. We have seen a dramatic rise in the percentage of internet users who have social networking sites from 2005 to 2010. In fact, in October of 2011, worldwide number of social network users, 1.2 billion. 1 out of every 5 minutes spent online was spent at a social networking site. By December of 2011, this graph, Facebook had grabbed a staggering 83% of the U.S. internet audience. By March of 2012, 901 million monthly active users on Facebook. On an average, more than 300 million photos were uploaded to Facebook per day. My wife was only responsible for 100 million per day. So the rest, that's a lot out there. Now, can you look? Can you, by the way, not just the photos, right, but all of us that have to hire private investigators, don't we love that checking in function? Isn't that great when a plaintiff tells you exactly where they're going to be? If all this information, if their privacy settings allow you to go to these sites and see the photos and find out where they're checking in from, the next question becomes, I mean, is there any limit to it? Well, sometimes there are. Sometimes their privacy settings don't let you in, and you get this. Ashley only shares some information publicly. If you know Ashley, send her a friend request or message her. And that's where we all kind of stop. And we have to ask ourselves, can we send that friend request? Obviously, we can't send a friend request to the plaintiff, but can we send a friend request to a co-defendant? The answer is no. Rule 4.2 says you shall not communicate with a person you know to be represented. That may be counterintuitive, especially if you and the co-defendant and their attorney are all working together. Got to be aware of that. San Diego Bar Association in 2011 came out and said, you know, a friend request is at least an indirect ex parte communication. And I think they kind of correctly said what you're really doing is sending a request saying, I would like to have access to all the information you're sharing on Facebook. Well, may I accept a friend request from a represented party? Well, comment 3 to Rule 4.2 says that the rule applies even though the represented person initiates or consents to the communication. So, if you know that she's a plaintiff and you receive a friend request from Sue McClient, do not confirm, okay? And yeah, I know, Sue McClient, it's Scotch Romania. May I tell my associate to do it for me? And the answer is no, you can't. Rule 5.1 says that a lawyer is responsible for another lawyer's violation if you order your associate or if you ratify the conduct. Well, can I tell my secretary or my assistant? No, you can't do that. Rule 5.3 C says a lawyer is responsible for the conduct of such a person, again, if they order or if they ratify it. Well, hypothetically, what if my associate always sends these requests and I don't ask him to, but I know that he's doing it? Well, if you are a partner at the law firm or if you are the supervising attorney and you know of the conduct, then you are responsible for the conduct. And the same is true under 5.3C if it's your secretary, your assistant, or another non-lawyer assistant. Okay, all right, let's see. How about this? May I have someone else send a friend request to an unrepresented party? Let's think now. We're talking about experts. We're talking about lay witnesses. I can't send it. What if I have a cousin send a friend request so I can see what's on their web? What if I have a private investigator do it? Well, the Philadelphia Bar Association in 2009 said, well, that friend request sent by your private investigator or by your cousin, it omits a highly material fact, namely that the third party who asks to be allowed access to the witness's page is doing so only because he or she is intent on obtaining information and sharing it with a lawyer. That's a pretty important thing. And because of that, the Philadelphia Bar Association felt that the friend request would violate 8.4C, which prohibits a lawyer from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. They went on to say it also violates 4.1. 4.1, comment 1, says a lawyer is required to be truthful when dealing with others on a client's behalf. And the Philadelphia Bar Association, in a little footnote, said, you know, we're not going to say one way or the other, but it might violate 4.3, which says that a lawyer shall not state or imply that the lawyer is disinterested. And so having someone do that for you violates that rule. Well, okay, I can't have the private investigator do it. I can't have my cousin do it. May I send a friend request to an unrepresented third party, like an expert, like a lay witness? Well, if you can't have them do it, can you do it? Actually, that addressed some of the concerns about the purpose for the friend request. So the New York City Bar Association said that an attorney or her agent may use her real name and profile to send a friend request to obtain information from an unrepresented person's social networking website without also disclosing the reason for making the request. Well, all right, we've talked about going on the offensive. What about the defensive? Do I have a duty to investigate my client and the witnesses? I don't know if you have a duty, but it's a good idea. All right, here's you got a case, the Wilgus case in 2009, where 4 days after the trial, a juror sends this email to the plaintiff attorney. Did you know your plaintiffs advocated the use of mushrooms and weed smoking and binge drinking all over the internet? Motion for new trial. Juror says, I promise, I only read it after the verdict. Motion for new trial denied. Best part about the email, the juror actually chided the attorney, saying, don't you think you should have addressed this issue and know such things so they can clean up their acts before court? Okay, well, may I tell my client to remove any bad video or posts from Facebook? No, you can't do that. Rule 3.4a, exactly what that juror wanted him to do, you can't do. You can't unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal. And I was able to find an example of it, a costly one, in the Lester versus Allied Concrete Company case, September 1st of 2011. The plaintiff attorney learned that there was a photo depicting Lester, who was the alleged widower, the grieved widower, clutching a beer can, wearing a T-shirt emblazoned with I love hot moms, and in the company of other young adults. He then instructed Lester through an associate or an assistant to clean that up, get that off the Facebook page. That cost him $522,000 and reportedly his legal career. The judge findings reflected that he had told his client to remove several photos from his Facebook account on fear that they would prejudice his wrongful death case. Costly thing to learn. May I investigate potential jurors online? All right, discovery's done. I've called for the jury. Now can I go online and open up Pandora's box? What can I find out from them? Yes, absolutely. You can go online and learn about your jurors. In 2010, the Superior Court of New Jersey actually found that a judge acted unreasonably in preventing the use of the internet by Joseph's counsel. In 2010, the Supreme Court of Missouri actually had to grant a new trial because a juror said, never had jury service before, turns out had jury service before, and when it was brought to their attention, the court had to grant a new trial in this criminal case. The court comes out and says, y'all should have brought this to my attention before. In light of advances in technology, it is appropriate to place a greater burden on the parties to bring such matters to the court's attention at an earlier stage. You want us to research the jurors? We will research the jurors. In fact, in 2011, the NYCLA Committee of Professional Ethics found that it's proper and ethical under RPC 3.5 for a lawyer to undertake a pretrial search of a prospective juror's social networking site, with certain exceptions that we've already kind of talked about. Lawyer does not seek to friend the jurors, subscribe to their Twitter accounts, send juror tweets, or otherwise contact them. Now this is just 9 days ago. 9 days ago, it's not in your materials because it occurred after it was submitted, but 9 days ago, the New York City Bar came out with Formal Opinion 2012-2, saying that an attorney may not, for example, send a chat, message, or friend request to a member of the jury. So we kind of know, we're feeling pretty good about what we can do. We can go online. The New York City Bar also said that you could go use search engines online to find out information, right? So this next question, may I visit a public web page for a juror? You think that's pretty obvious. Well, of course you can, right? That's what you're thinking, right? Well, 9 days ago, they dropped this bomb as a part of this opinion. It says, finally, research using services that may, even unbeknownst to the attorney, generate a message or allow a person to determine that their web page has been visited, may pose an ethical risk even if the attorney did not intend or know that such a communication would be generated by the website. Think about that for a minute. Okay, so it's not that you sent a friend request to somebody or you went and you sent a message to someone, but if you go to a site and you're visiting the site causes a message to be generated and sent to the juror, you may have an ethical problem according to this opinion. Well, what about Facebook? Does that happen if I go to Facebook? No, it doesn't happen if you go to Facebook. Your visiting doesn't cause a message to be generated. But remember that it said the disjunctive or. It used the disjunctive or. It said, or allow a person to determine that their web page has been visited. Now, on Facebook, can you determine if somebody has visited your web page? No, you cannot do that on Facebook. However, you can on LinkedIn. So if I've got a juror and I go to LinkedIn, according to that opinion, if they can see that I visited their site, by the way, the $8 upgrade premium membership for LinkedIn allows you to see that. But that's not just the $8 upgrade. depending upon your settings and the juror's settings, you may be able to see who's visited your web page without the upgrade. So now, have I violated the code of ethics? I'll ask you another question. What if you find a search engine and you're being sued by a company and you don't know how they set up their website? Or you have a juror who's the president of a company and you want to go to that web page because you found it. Do you know how they set it up? If you're going to the website causes a message to be sent to him, or if you're going allows him to see that you visited, have you just violated the code of ethics? That opinion, just 9 days ago, in my opinion, it's a bombshell. People are going to be talking about this and studying this for the next year. And the question is, what can and what can I not do? By the way, if you say, I'm not going to worry about this, I'm going to hire a jury consultant. No, because as an attorney, it's your job to find out what your jury consultant is doing and to find out what he's going to go on Facebook. Are you going to go do LinkedIn? Are you going to go to any website with the name? All right, well, all right, we've picked the jury. Am I done now? May I monitor jurors' postings online during trial? Of course you can. You can passively monitor such jurors, such as viewing a publicly available blog or Facebook page. That was from 2011. The opinion 9 days ago says, with the noteworthy thing, that perhaps you can't if you're monitoring a site that lets them know you're monitoring it. All right, guys, well, we didn't set the system up, but it's an adversarial system. I have a client to represent. If I find out that one of the jurors is tweeting during the trial or blogging about the trial online, and this particular juror is 100% in favor of my client, this juror realizes that the opposing counsel is wrong, that the evidence is there, and they're tweeting about it, what is my duty? Well, Rule 3.3 says I have a duty of candor toward the tribunal. The New York Rules of Professional Conduct say a lawyer shall reveal promptly to the court improper conduct by a member, and that imposes a duty to report. And a lawyer who learns of juror impropriety is bound to promptly report such propriety to the court. Well, what if my client doesn't want me to? Well, UCLA Law Review article recognized comment 12 is what's really in play here. Comment 12 says we have a duty to take certain remedial measures and a duty to protect the tribunal. So in 2011, the NYCLA actually came out and said, this is so even if the client notifies you she does not wish the lawyer to comply with the requirements of 3.5. So, yes, the internet. It is irresistible as Pandora's box, but it is a box that our clients want us to open. It is a box that our profession is still struggling to figure out how we can open ethically. What I'm here to tell you today is this. Don't be afraid of the box. The only thing that you are setting free is the truth. Thank you.